Hi, I am Jeffrey Wernick, and here with Bruce Fein for another Fine Points. And today we'll discuss is all this conversation about whether there is a constitutional crisis. Is it hype or is it not hype? Um, so I think that we're really fortunate to have somebody of Bruce's caliber to have this conversation. I would like to remind people the beginning of this conversation we'll have with Bruce is, and Bruce can clarify for himself. Bruce's roots of his political involvement has been essentially with the Republican Party. So Bruce is not a progressive liberal in any respect. Bruce has worked in several administrations. They've been Republican administrations, including the Reagan administration. And there's probably been no administration post World War II is committed to really limiting government as Reagan did. So when we have these conversations about, and Bruce has also lived through previous quote constitutional crises since he was intimately involved in in Nixon's trials and tribulations when he was there at the Office of Legal Counsel in the White House. So Bruce is a neutral observer, someone committed to the Constitution and the value embedded in the Constitution, and his loyalty and faith and fidelity, excuse me, is not to a political party, but the founding principles. And Bruce, do you think that's a fair and accurate description of you?
Yeah, that's very accurate, and thank you, Jeffrey. And I would add, there has been such a corruption of the Constitution, really, for so many years, at least going back 30, 40 years. I've drafted articles of impeachment against Bill Clinton, against second Bush, Cheney, Obama, usurping the war power, flouting the Fourth Amendment, warrantless surveillance on everybody, not taking care that the laws be faithfully executed, whether the Democrat or Republican. And in fact, I excoriated then first House Speaker Nancy Pelosi, 2006. The first thing she said is impeachment's off the table. I said, really? You get to wipe out impeachment? This is because she thought it would handicap the Democrats to defeat the Republican candidate in 2008. Said, you can't take impeachment off the table. And in fact, Pelosi herself was implicated in knowing about the torture program and staying silent about it. But my oath from the very beginning has been to the Constitution of the United States. And that's why I fought, and very successfully, when the Nixon tapes case got to the United States Supreme Court. It was the United States of America against Nixon. It wasn't Nixon versus whoever was holding the tapes. And otherwise, we're not going to survive as a republic, if we can any longer anyway. We have to be unified behind process. And if you don't win in that process, you go back, another day and make a better argument and a better case. But you don't abandon the process. Never do the ends justify the means. And that's what we're confronting right now, is that a really, really strong possibility. And Jeffrey, when last week, this week, Chief Justice John Roberts, without prompting, made a statement from the Supreme Court that the proper executive branch reaction to a loss in a lower court is appeal, not going to impeachment because you don't like the decision made. That's been an understanding in the United States for 220 years, since then Justice Samuel Chase was acquitted when Jeffersonians wanted to impeach him because his views of the Alien and Sedition Act. Since then, we've never had any impeachment of a judge just for making an erroneous decision. You go through the appeal process. If that doesn't work, you can amend the Constitution, but you have to stick with process. There is nothing in the Constitution that provides a stopping point for violating some court orders and not others. And let me add, Jeffrey, on that score. Abraham Lincoln despised, as a matter of interpreting the law, the U.S. Supreme Court's decision in 1857 in Dred Scott and Sanford, saying that no black, free or slave, could be a citizen of the United States, and Congress could not ban slavery in the territories. And yet he said in his first inaugural, we can't just flout the decision. We can work to oppose it. We can amend the Constitution. Indeed, the Constitution was amended to overturn Dred Scott, but he said the consequences of starting to flout decisions of the Supreme Court because you don't like them doesn't have any stopping point, and we'll soon be back to the law of the jungle. And that's what the viewers of this podcast need to recognize. It's these process keeps us together, or we'll become unglued.
Can it also be said that there was also wisdom involved, even though Madison probably disagreed with the Marbury versus Madison decision,
Yeah.
that a decision was made at that point in time, but by both Jefferson and Madison, that they did not want to create a constitutional crisis by going and challenging Marshall and claiming that they had that Marshall could say whatever he says, but they don't care.
Yeah. Well, exactly. They understood as well, and they were there. What we would call present at the creation, so to speak, and they understood the consequences that would follow. And even the one case, Jeffrey, that sometimes is cited as showing that there is a precedent for a president flouting court order is Andrew Jackson. And this relates to a decision by Chief Justice John Marshall. It's called Worcester against Georgia in 1832, saying that Georgia could not require licenses for chaplains or religious figures to visit and practice on an Indian reservation, that the relations between Indian tribes and the United States was an exclusively federal one. State laws were preempted. And therefore, two chaplains who had been convicted under Georgia law should be released. And the case never got to a situation where Andrew Jackson was tasked with enforcing the judgment. There was a political resolution of the issue. The Georgia governor agreed to pardon the defendant, so they went free. And the case went, and then Andy Jackson changed his mind about the supremacy of the federal government when South Carolina threatened to secede because of high federal tariffs. And Andy Jackson said, no, you can't do that. Otherwise, there'd be federal troops in Charleston well before William Tecumseh Sherman. So that washed out, and there was never a willingness of even President Jackson to not execute a judgment issued by John Marshall.
Let's go, since you referred to the already, let's go to start off with the Alien Enemies Act.
Yeah.
Now, while the Alien and Sedition Acts expired, there was support by both Jefferson and Madison for the Alien Enemies Act. But given the fact that supposedly the form of constitutional interpretation is a public meaning originalism, is there any evidence whatsoever? And from my understanding, the application, like during World War II, which was the last time prior to Trump calling for its application, was when we put Japanese in detention camps. Were we putting all Japanese in detention camp, or were we choosing a handful, or
no
criteria for the use of the Aliens Enemies Act when we were at war with Japan?
Yeah. When we were at war with Japan, the Alien Enemies Act was used to deport some, but not all, aliens. Most of the permanent resident aliens of Japanese ancestry were herded into concentration camps. So that's not a concentration camp, is not a deportation order. They were in the United States of America. There were some that could be deported and were. But I want to underscore John Adams, who was the president at the time the Alien Enemies Act was passed, he never used it. He didn't expel even one person under that act. And the express text of the act, Jeffrey, says, when there is a declared war against a foreign government or foreign nation, or a foreign government or foreign nation has invaded the United States, then this authority without customary due process to deport an enemy alien arises. Now, what Mr. Trump, through his lawyers, argued to the district judge was that this Venezuelan gang is currently conducting guerrilla warfare against you and me and all of Americans as kind of a Gestapo force from President Maduro of Venezuela. The judge asked, is there any evidence of this? And the argument was, we don't have to have any evidence. Once the president declares anything that he says is national security, you must accept it as true, even that the moon is made of green cheese or that there's a Martian invasion. And the judge said, no, that cannot be the case. And of course, I think everybody on this show would agree it's preposterous to suggest we are at war with Venezuela, either directly or through these gangs.
Okay, so let me get a couple things. The president had pretty broad discretion to deport people who are alien enemies once there was a declared war, correct?
Correct. Yes.
Now, who declares war?
The Congress of the United States, and that was what was anticipated.
Okay.
That, for example, in World War I,
the president is only conveyed this power if Congress first acts by declaring war.
Yes. And Jeffrey, I apologize for interjecting, so that up until Mr. Trump, the only presidents who had invoked it were after declarations of war. The War of 1812,
World War I,
World War I, and World War II. Yeah.
Right.
So that was the understanding. That only Congress can declare war. Otherwise, it's not a war. And that it's very clear in the express language of the statute. It says a declared war triggers the authority, not whatever you want to make up and call something a quasi-war, whatever. Presidential wars don't count. We obviously are not in declaration. We are not have a declared war against Venezuela. Now, the other trigger is, well, how are we actually invaded by a foreign nation? Of course, we're not invaded by Venezuela. It's ridiculous. But that's the only argument.
If we're being invaded by Venezuela, why isn't there a declaration of war being made? Wouldn't it be kind of negligent of the president of not to declare? Venezuela is invading us, and we're going to defend this invasion by deporting 300 people.
Yeah.
Okay.
Yeah. You'd ask, why hasn't he asked Congress to declare war? He hasn't.
Yes.
And Congress hasn't on its own declared war.
Has he made a speech talking about how Venezuela is an outlaw nation trying to invade and overthrow? Has there been one speech made by him or any member of Congress with the claim that Venezuela and Maduro is organizing an invasion or has actually invaded the United States?
No. It's limited to the courtroom.
Yeah. Has anyone got up and said, we are being invaded by Venezuela?
No. Other than in the courtroom. That's the only place he stated. And not even in the UN Security Council. I think it's such an embarrassment that he's trying to keep it secret. And that's why you see a lot of, because most of the reporters aren't there in the courtroom and hear the argument. I don't know whether you dignify it by saying it's an argument. It's propaganda, political propaganda, to try to rally people for his immigration program and what he claims is necessary to keep his immigration promises in the campaign. But obviously, to anybody who's not deranged, it's a ridiculous argument to make. And that's why even in the Court of Appeals, they're not going to succeed. I think they're smart enough not to take this to the Supreme Court because they would lose, in my judgment, 9-0. I don't even think they get Alito or Justice Thomas. But anyway, and this is really an extreme case, I think, of how far this administration is willing to just flout the text of a law, totally distort common meanings of text and language to do whatever they want to do.
Well, I think that should have been evident. I don't want to bring up 2020 election, but I think that's pretty evident given the arguments that were made on what he asked Pence to do, in 2020. I mean, their plan of putting in all these fake electors, even though the executive branch has no role in the selection of electors, we all know that this was being administered, from the White House, and one of the primary people involved in that already had pleaded guilty in Georgia for his actions. So, so it shouldn't be an issue that should be subject to dispute. So, we do know that Trump had interpreted the role of the vice president to basically, at his sole discretion, to ignore the certification that states were insisting upon. And if a state said, "Here's our certification," he could just say, "I'm not accepting it." Okay. So I mean, and his own lawyer had said, "Well, this might buy us time, but we're going to probably lose, unanimously at the Supreme Court." So I don't want to bring back 2020 to get over a debate over it, only to make the point that the fact is that this is a guy that always looks for a loophole, no matter how weak that loophole is, and he'll try to exploit it until somebody stops him.
But Jeffrey, I don't think it's a loophole. There's limits to how expressed the language can be. The 12th Amendment, there's not a loophole. It says when the joint session of Congress convenes and the electoral votes that have been certified by the states are present, says then the vice president shall count the votes, the state certified votes, not that the vice president shall decide which ones are valid and which are not valid. And indeed,
the Constitution doesn't say the vice president can count the votes he wants to count and ignore the votes he wants to ignore. You mean that's not in the Constitution?
No, and it's so clear, Jeffrey. This had never even been conceived in 230 some years. So that's a pretty strong evidence.
I mean, that just validates the point I'm really trying to make. Is that Trump is not above or below or whatever you want to say it, making outrageous, ridiculous, absurd claims.
Yeah, exactly right.
He has a track record for doing this.
Yes. And even before 2020, this was in 2019, Jeffrey, he made the following statement, and I'm quoting, on July 23rd, 2019, "Then I have Article 2, where I have the right to do anything I want as president." Anything. He's never retracted, never modified, never tried to disturb any of that assertion. It's another way of saying I'm a king.
Yes. And he also says the law doesn't apply to him because he's saving the country.
Yeah, because that's citing Napoleon for that proposition.
So that's basically his attitude. His attitude is, I'm saving the country. I can do what I want. Anyone that gets in my way are people who are unpatriotic because they're getting in the way of me saving the country. And what's the evidence that I'm saving the country? 80 million people voted for me. So that's the evidence that I'm saving the country. I have a mandate. So, I checked. I checked that. I checked on Grok, the Musk's AI, and I think the only, and since 1960, only 2 elections were closer in an electoral vote, and I mean in a popular vote, and that was in 2000, the Gore Bush election had a smaller margin of popular vote difference than the 2024 election, and as far as the popular vote in 1960. But so basically, since 1960, all elections but 2 had a broader popular vote margin than 2024. So that doesn't seem to be much of a mandate at all, because it's one of the smallest popular vote margins, in the last 60 plus years. Then I checked the electoral. Then I checked the electoral vote college. Okay, since 1960, and there were Trump won by 86 electoral votes. There were 10 elections where the electoral college was won by more than 100 electoral votes, including several over 200 electoral votes, including several over 400 electoral votes. So we have someone who claims he's got the biggest mandate ever in the history of government elections. I guess Washington getting 100% of the electoral votes was a less of a mandate than Trump got, because Trump is asserting he's got the biggest mandate in the history of the country, while Washington got all the electoral votes. But since 1960, on the most part, every winner had a bigger margin of electoral popular vote and a bigger margin of electoral vote. And yet Trump claims he has an unprecedented mandate, and that unprecedented mandate means he should not be subject to judicial review.
Yeah.
I mean, and people are
Jeffrey, I got to intercede, Jeffrey. Number one, Trump already has announced that he has now surpassed George Washington as number one, not just in electoral votes, but in terms of stature, in terms of courage, in terms of accomplishments. But the second thing is, and this is important, it does not matter how large a mandate you have. It is not possible for the voters to give you a mandate to flout the Constitution. You can't do that. You can amend the Constitution with a mandate. And indeed, part of the reason why Roosevelt in 1932 was elected to repeal the Prohibition Amendment, which was repealed in the ordinary course of amendment process. But Roosevelt, who had a far greater victory mandate in 1932 running against Herbert Hoover, he passed 77 statutes to bring in the New Deal. He didn't do this by executive order. You get statutes. Trump does everything by executive order. It's like the Congress doesn't exist. Congress apparently doesn't care, so they can escape responsibility. But the most important thing I want to stress at this point is the whole reason is the Constitution exists is because the rights that we enjoy don't depend upon the outcome of elections. It doesn't. You can't get a mandate to violate free speech or the right to have bear arms or due process.
Isn't the principle? I'm the president of the country. Okay, I get up there January 20th, Washington D.C. Supposed to put my hand on the Bible, put my hand up. I swear an oath. My oath is to protect, defend the Constitution of the United States. That's my oath. Okay. Now, if I make a statement saying the country now is no longer a constitutional republic, but I got a MAGA mob, and this MAGA mob supports me, so that basically this MAGA mob supports me, so whatever I want to do, I can do because I got a large MAGA mob. That's not a majority. It's a plurality. He didn't get 50%. So he got a plurality, but he's got a large mob, and that large mob gives him the right to do whatever he does. Isn't that a breach of the Constitution itself? Because
absolutely,
no one who understands the fact that we're a constitutional republic would ever say, I got these amount of votes, so that gives me the right to do whatever I want to do, because that's exactly what the founders called mob rule and tyranny.
Yes, that is exactly
he's advocating for rule by the MAGA mob.
Yes.
With him as the head of the MAGA mob.
And George Mason, who was a delegate to the Constitutional Convention, when they had an interchange with Mr. Madison about impeachable offenses, made clear an attempt to subvert the Constitution, not an actual attempting to subvert, was sufficient to meet the impeachment threshold. And we're seeing attempts to subvert the Constitution every hour. Whether it succeeds or not, it's not because the intent is not there. Because impeachment was intended to be prophylactic, not just remedial after the fact. And I think one of the reasons why people are so reluctant to even contemplate impeachment, they do not understand. Impeachment is the most civilized, mild remedy you can give for an abuse of power in the history of politics. This is not the guillotine of the French Revolution. You simply lose your job. Just like Jeffrey, if you're CEO and you don't do the job right, you violate the bylaws, you get kicked out. Okay. Otherwise, you go live your life as you want to. So this idea that somehow that impeachment is some kind of coup d'etat is utterly ridiculous. And I think even in terms of, well, at least you have a different person there who's administering the government. But say if we have an impeachment of Mr. Trump and it succeeds, J.D. Vance would be the next in line. I think he wouldn't probably duplicate Trump because he wants to stay in power. But it's not like it falls to the Democrat Party. And if he's impeached, then it goes to Mike Johnson, who's the House. It still stays in Republican hands, who are still very conservative. And it just means, but you got to comply with the Constitution if you want to stay in office. It's not a political revolution of any sort whatsoever. It is a very mild remedy.
It's just making sure who is ever in power is complying with their oath of office to act consistent with the framework of the Constitution and be obedient and protect the Constitution and defend the Constitution, not subvert the Constitution, not overthrow the Constitution, which is apparently what this administration, is doing. It's doing a power grab because it thinks it's got a, well, it is evidence that the House won't stop him. And there's a faith that the Supreme Court won't stop him either. So that until his wrist is slapped or his face slapped or whatever, or he's smacked in the face, he's going to keep challenging, testing the boundaries, and knowing one thing he's confident of. Whatever he does, excuse me, this House will not bring articles of impeachment against him. So he could just, so there's no downside for him to grab as much power as they can when the majority party in the House and Senate are willing to give him everything, and he thinks the worst case is he'll lose a few battles at the Supreme Court, but ultimately he's got a Congress that has decided to delegate its constitutional responsibilities to the executive branch. To what extent can a Congress renounce its? Can a Congress say, I'm giving the president, I'm giving the president the blanket right to, I'm giving a blank check for the president to declare war against anyone he chooses?
No, you can't do that. And I've written numerous articles about this. The whole purpose of the declare war clause was distrust of the president's ability to make a measured decision because they're tempted to concoct excuses for war to aggrandize power. That's what the framers said over and over again. We will never, ever trust the executive with a war power because in times of war, the president gets all the jingoism, the appointments, the money, the absence of due process, the secrecy. So the temptation is to concoct an excuse was overwhelming. So if you permit Congress to delegate the war power to the president, the whole purpose of the clause is defeated, and that's why the declare war clause is not delegable. Now we can look at something that's a parallel, Jeffrey, but it's not exact. The U.S. Supreme Court has held a case called Clinton versus New York that Congress could not delegate its power over lawmaking and especially taxation to the president by giving him line item veto, where there is no line item veto in the Constitution. He either signs a bill or he can veto it, but he can't pick and choose. And the Supreme Court said Congress cannot delegate its legislative tax power to the president. Similar, but that's a lesser power of Congress than the power to declare war. That's the most important power in all of the Constitution, because in times of war, the law is silent. It legalizes first-degree murder. It's a Rubicon you want to go over very, very seldom. So the Congress couldn't do that. And let me give another example, Jeffrey. Could Congress enact the statute say the president shall promulgate an internal revenue code? Really? He'll decide what the tax rates are, what deductions are, and what is income and what is not? Obviously not.
It's interesting you raise this point because his Secretary of the Secretary of Treasury,
yes,
and the Commerce Secretary has each said that they want to use tariffs to replace the income tax.
Yeah.
So if he's using tariffs to replace the income tax, isn't he setting tax policy that really is the purview of Congress and not the president?
Yes, exactly right, Jeffrey. And in fact, for many
he wants to set up a whole new bureau, External Revenue Service, because he wants to replace the income tax. So, he's made conflicting things. He said, here I'm using the tariffs because I want to do things. Here's reciprocal tariffs. But ultimately, he said the objective of this policy is to substitute tariffs with an income tax and to have tariffs be the sole source of revenue, for funding government. So that seems to be, does the president set that or does Congress set that? It says to me, the Constitution says Congress sets levies and duties. So, how is it constitutional that he's busy trying to set tariffs on his own and use that as a substitute for, he's using it to fund government. He's not using it. He's claiming he's using it. Well, today I'm using it to fight, fentanyl coming into the country or immigrants coming into the country. Or, is the question is, even if I set up a reciprocal tariff policy, is that really foreign policy? Or is that a policy that Congress should do, or the president can do that, where the president can unilaterally set up this, these quote, reciprocal tariffs, then especially because the ultimate goal of these tariffs is to replace the income tax. So I don't understand how that could be viewed as a presidential prerogative, since the Constitution doesn't give the president this authority whatsoever. And the only authority that Congress seems to have given it over time is temporary tariffs for national security purposes.
Yeah. Well, it wasn't always that. At the outset, Jeffrey, tariffs were typically negotiated as treaties. A treaty is defined as an agreement between two sovereigns. And so, like the Jade Treaty was the very, very first very controversial treaty. It was between the United States and Great Britain. And that's how tariffs were part of the
treaties. Treaties need to be ratified by the Senate. By
2/3 of the Senate. That is correct.
Okay, so Congress is involved. The president just doesn't set a number, and that's it.
Okay. Yeah, not only was Congress involved, you needed 2/3 of the Senate. A simple majority wasn't good enough. Okay. But the really beginning around the time of the Mexican-American War, the treaty power was too obnoxious to presidents. Said, well, it's too hard to get 2/3. And so there was an attempt by the Democrats. They wanted to annex Texas. They thought it may help the balance of slave states and free states. But they couldn't get 2/3 of the Senate to ratify. So they said, well, just do it by a statute. All the previous annexations were by treaty. So, but wait a minute, the whole reason why you wanted a treaty, because you needed this supermajority, because it concerned of something of vital importance to our sovereignty. So they decided and said, okay, we can't get 2/3, we'll just get simple majorities in the House and the Senate, and started to water down the treaty power. So after that decision, then typically tariffs were set by statute, House and Senate, but simple majorities rather than 2/3 in the Senate. But these were huge, huge issues, Jeffrey, in political campaigns in the congressional level. That was the heart and soul. And they were running, tariffs were bringing in surplus before the income tax. We were running surpluses in our budget from the federal government. And big issues were, what are we going to do with the surplus? Are we going to give it back?
And that's when the government was spending about 2.5% of GDP as government expenditures, and now it's about 10 times that amount as a percentage of GDP than it was then. So it was a very different, because there was a very small government then, and it isn't a very small government now. So it's a very big government now. So there's a big difference between funding government spending that's 2.5% of GDP versus 25% of GDP is a huge difference. But what you're saying is this has always been done with congressional legislative involvement.
Correct. Exactly.
Either through statute, which was the House and Senate, or through treaty, which is just the Senate. Is that correct?
That is correct. And also, the framers understood, and this is Madison again writing the federal papers, that they viewed the power of the purse was critical if you're going to hold the executive account. You can't do anything without money that's appropriated by Congress or raised by Congress. And they understood that was almost at the apex of legislative powers. And now it just gives it away. And then there's no pushback, nothing on the legislative side. It's like they're craving anemic wallpaper, just watch and doesn't want to decide anything. It's really quite stunning because, when you and I were much earlier in age, there were real giants in the House and the Senate. Remember Russell Long, you're not going to get any taxes without Russell Long's approval. Wilbur Mills on the House side, Ways and Means Committee. They were the ones who could hold press conferences. They were viewed as important as the president on these matters. Now, you couldn't even think of a name of anyone who would rise to that stature. They just disappear.
Jim Wright tried to take foreign policy away from Reagan, remember?
Yeah, and go down to Nicaragua and talk to the Sandinistas. Yeah.
Yes.
So, I mean, but now that nothing like that, you can't even imagine happening these days. They don't even hold hearings. We spend $2.3 trillion in Afghanistan and no oversight hearings. What the heck were we there for? So, I want to underscore to our audience, the only way Congress is going to change, if we write in and complain, hey, why are you there? You're not doing the job. You need to make these decisions. We need to be able to influence them. They're not presidential decisions. You have an oath to uphold and defend your prerogatives. You're not doing that. Unless that public opinion changes, Congress is not going to do anything. Just keep shrinking, and they'll disappear like the Cheshire Cat.
And so now that Trump has already got the legislature, the House and Senate, under his pretty much absolute control, he's looking to accomplish the same with the judicial branch.
Yes, and one of the things I think that at least gives some kind of periscope into Trump's mind, he has a majority, as you pointed out, in the House and the Senate. And they are basically poodles, will do whatever he wants. But he's not asking Congress to do anything. He's just issuing these executive orders. So why is he doing that? Because he wants to set precedents to mean he can do anything he wants. He doesn't want Congress. Now, take another example with regard to President Roosevelt in 1932-33, the first 100 days. He got 77 statutes, not executive orders, statutes that brought in the New Deal, the National Recovery Act, those sorts of things. And his mandate, so to speak, popular mandate, was 3 times or more than Trump's. But we still were working within the framework of the Constitution. Now,
go ahead, sorry.
I was just saying, now there is no constitutional framework. We just have the White House, and then he does things, and then he butts heads with the courts, and Congress just sits as a spectator. Congress was supposed to be the first among equals. Now it's the last among unequals. What happened here?
It seems to me Trump can create a lot of noise for House to vote to impeach a lot of judges. But from my understanding, my recollection of the Constitution, when the Senate handles the trial for the impeachment to occur, it requires 2/3 approval of the Senate. Now, anyone in the House, who's proposing these bills to impeach these judges, know that they're never actually going to be convicted by the Senate. Okay, they know they're not going to get half the Democrats to support the impeachment of these judges, and they might not even get every Republican. So I don't think any of them believe that they're going to win. So you got to believe the only reason they're doing this is to intimidate these judges.
Mm-hmm.
So they're like a mafia. So and they're in the intimidation racket because one is they know these charges are illegitimate, and they know these charges will never succeed to actually impeach the judge. But what it might succeed is intimidating the behavior of judges. I hope that's not successful. So it seems to me the judges that they're criticizing, are actually the judges who are the last line of defense we have to uphold the Constitution, and not have a president with completely unchecked powers.
Yeah, no, that's exactly right, Jeffrey. And there are other circumstances, I think, because we're not talking in a vacuum, that are very, very troublesome with regard to whether we will have some kind of lurch of the White House to gather all powers and simply dissolve all the other branches. And that is because we have the most conservative jurists, lawyers, who find what Trump is doing beyond the pale. The one example most recently is the acting U.S. Attorney for the Southern District of New York, She was a star of Justice Antonin Scalia. She clerked for J. Harvey Wilkinson, who I know because I work with him at the Justice Department and the U.S. Court of Appeals for the Fourth Circuit, as solid as you can get for conservative credentials. And she said, I cannot work with an administration that trades justice, i.e., the indictment against Eric Adams, for his assistance and maybe helping out on immigration, that has nothing to do with the merits of the case. It violates my oath of office to take care of the laws faithfully executed, in accord with canons of interpretation and construction. So the people who are balking here, they're not Code Pink. This is not Kamala Harris. This is not the Democrat far left. These are the most conservative thinkers on the Republican side. I mean, take myself, Jeffrey, I probably would agree with at least half, if not more, in policy of the cuts and the excess size of the federal government, maybe even more than half, because I've seen how wasteful this is. But I can't say the president can do it on his own. You need to go to Congress because process is everything. I think both of us agreed. This is outrageous how big the government is. But we can't just throw out the process and say the end justifies the means. The ends doesn't justify the means. We need to make our case, force Congress to get rid of this Department of Education through a proper way, get rid of USAID in a proper way. And if we have strong arguments, we should be able to win. If it doesn't happen tomorrow, we have elections, we have platforms, you have freedom of speech. But it's the most conservative thinkers. And one of my friends, Michael Luddick, super conservative, who sat on the U.S. Court of Appeals for the Fourth Circuit, is saying the same thing. We're shredding the Constitution. And don't worry, this is Trump now, but there's going to be liberal in that White House at some time in the future. And all the things that you're setting right now are going to turn back and you'll be on the end of your own petard.
Yes, I mean, I think it's terrible that in my Substack, I think I published it this morning. I wrote about declaring, the vandalism against Tesla dealerships as a domestic act of terror. Somehow you can vandalize any other property, and it's not considered an act of domestic terror. But if it's a Tesla dealership, it is. And I'm sure many MAGA people support this concept of having it declared so you can vandalize a GM dealership and you're just a vandal. You can vandalize a Ford dealership and you're just a vandal. But if you vandalize a Tesla dealership showroom, you're a domestic terrorist. Now, how many people, if I think they're being honest, if tomorrow George Soros bought Tesla, okay? How many do you think that Trump would get out and say, if you continue to vandalize Tesla owned by George Soros, you're a domestic terrorist? So the issue is not the act itself and who the act is against. It's against the owner of that. So this is a protecting. So basically, every crime should be treated independent of the identity of the perpetrator and the victim. We should just look at the crime itself, independent of who did it and who was the. That's clear. That's also the society they say they want, right? They want a society where there's no mention of race, religion, none of this DEI stuff. Somebody that they're removing Jackie Robinson memorials in the Defense Department, because he's black. So therefore, if he must be a DEI person there, the people holding up the flag at Iwo Jima, because they're not all white, got to remove that because that's DEI. So it seems like if they're not white, then therefore they're DEI because they didn't get there on their merits. They got there because of the skin color. So
yeah. Jeffrey, I've got to interject, Jeffrey. I'm old enough. I saw Jackie Robinson play for the Brooklyn Dodgers, right? Second base.
Yes.
Jackie Robinson was no DEI appointee. He was most valuable player, right? So I can testify. I saw him. Braves Field. It used to be the Boston Braves and the Brooklyn Dodgers.
Yep. There must have been some white player who really was better than him. But Could have stole more bases, hit for better averages. So I'm sure every Dodger was sitting on the team saying, "Fuck this guy." I'm sorry, my expression. Why do we have to live with? Why do we have to live with this DEI hire here?
Yeah,
This affirmative action guy. This Willie Mays. He really Willie Mays. Really, what? Why do we need this guy in Willie Mays? Say hey, okay? You know what? We got to have this say hey guy out there. He can't play baseball. Okay. What's this Puerto Rican doing on the Pittsburgh Pirates? Roberto Clemente? Puerto Rican. We don't need Puerto Ricans on our team. Okay. I'm sure there's a white guy better than Roberto Clemente. Okay. What was he? Okay. I'm sure he won 4 batting titles, but if we would have had the white guy there, he would have won 10 batting titles. Okay. So he won the MVP in the World Series. We would have been in a lot more weird series without Roberto Clemente. Why do we have to put up with this Roberto Clemente from Puerto Rico? Okay. Some white guy would have been there and we would have been much better. Okay. So, this is the logic. Okay. They're all, but given the context of that, suddenly the identity of Musk becomes relevant. Okay. So, then you're a domestic terrorist because it's a Musk-owned business, and Musk is entitled to certain privileges from an administration that claims that nobody gets access to any type of privileges.
Except remember,
how absurd is this?
He got free marketing from Trump in taking the Tesla to the White House lawn, and Trump acted as salesman for him. I said, this is insane. But what you're pointing out, Jeffrey, is the difference between a government of laws and a government of men. In a government of laws, it does not matter who's plaintiff, who's the defendant, who's accused, who's the prosecutor. You apply even-handedly the justice norm that's enshrined in the law or the Constitution. And I don't believe anybody today can say with a straight face that we'd have a government of laws, not of men. And it's not just the Republicans or Trump. Look at Hunter Biden and Joe Biden. I mean, that is ridiculous. You're telling me that the pardon came because it was an even-handed evaluation of whether or not there was overreach in prosecuting Hunter Biden when it was Joe Biden himself who had the administration that prosecuted him? Anyway, and it goes back in other circumstances too. The pardon of Mark Rich, one among many, where we have political presidential pardons that undermine the obligation to take care that the laws be faithfully executed. But we come back. That's what gives the legitimacy to government when it acts, because we have neutral norms of law that apply to everybody even-handedly. Even when it's imperfect, that's our aspiration. We don't openly and notoriously say, no, it's just who you are. If you have enough money, you have enough political context, the law doesn't apply to you. And that's what we confront today.
Okay. In the judicial system, what's been the practice when I want to go back to this case of the Venezuela and the flights to El Salvador?
Yeah.
Yes. So what's been the tradition, the normal practice, the accepted practice, that when a judge gives a bench ruling that's specific and explicit and yet hasn't put it in writing, is the standard practice is that whatever the judge says that's explicit and specific has zero meaning until it's put in written form?
Jeffrey, if I ever told the judge that, I'd be held in contempt in a nanosecond. When the judge makes a ruling, it's called a ruling from the bench. It's effective immediately. Because unless this is unusual, there are court reporters, there are transcriptions all the time. Now, they maybe take a little while. Sometimes they have audio tapes, and then the court reporter types it up after the fact. No, the judge makes a ruling from the bench. That's an order. And if any lawyer ordinary lawyer told the judge, listen, until you write that down, I'm not going to comply with it, he'd never get his light of day in that courtroom ever again.
So that's absurd statement.
Yes, it's complete absurd statement.
So it's clear they gamed the judge because they sent the flights after they got the verbal bench ruling, correct?
Yes, that's correct. That's correct.
Now, is it also true that once an airplane controlled by the U.S., completely under the control of the executive branch, is there an action that's completely controlled under the executive branch that the Supreme Court has no jurisdiction over?
No, this is I think the misconception that's been created by some of the
But
Trump
that's what they
lawyers.
said. They said once it was in international airspace,
Yeah, the
that
defendant,
they had.
the aircraft is not the defendant here. Mr. Trump, in his official capacity, is the defendant. And that's why the jurisdiction over the plane, as long as the president or the defendant has the power to alter and change and withdraw the flight path, there's jurisdiction to say you have to turn it around.
So that's
He
also a
doesn't.
ridiculous argument, right?
Yeah, it's completely ridiculous. Sorry. The key element is that the defendant is in the United States. The authority that the judge is asserting is over the president of the United States, not over the aircraft. And as long as the president has authority to order the aircraft to return, there's authority for the court to order him to do so. Let me give a parallel example, Jeffrey, where when we had initial litigation over our detainees, the enemy combatants in Guantanamo Bay, the argument was made, no, there's no jurisdiction because Guantanamo Bay technically is Cuban sovereign territory, and we lease it. And the courts and the Supreme Court said, well, that doesn't matter. We can issue writs of habeas corpus and demand you to produce the body because you are in the United States, you are subject to our jurisdiction, and you can go get the body from Guantanamo Bay. The same thing is relevant to the Venezuelan deportation issue.
So in other words, given the logic that they've made, that once a plane is out of U.S. airspace, that therefore the courts cannot opine on it, which I mean would that also mean Congress can't opine on it. The president can go out and say, I'm going to declare war without declaring war, and I'm going to send nuclear weapons out against China, Russia, and a few other countries. Okay. Then as Congress becomes aware of it, it says, no, you can't. And the president says, sorry, you lost jurisdiction because it's now an international airspace. What do you think of that argument? So do you think that it would no longer be, even though the president, as you pointed out, still has control over that aircraft? Okay, the fact that the president in the United States has control over the aircraft because the aircraft is out of that jurisdiction, that means the president still controls it, but it's no longer in the jurisdiction of Congress or the Supreme Court or the courts.
No, it is utterly ridiculous.
Is that a fair description of what they're claiming?
Yes, that's a fair description of what they're claiming. It's a completely idiotic argument.
How can anyone who's not a moron find any validity in any of this stuff? Judges get up and I say, here's my ruling, and people say, good, okay, nice. You're really only talking to yourself, okay? So is the judge just, when the judges are making bench rulings, are they just talking to themselves?
Not any of the judges that I've ever appeared before. They expect their bench rulings to be complied with. And ultimately, in a bench ruling, Jeffrey, there's an audio recording or there's a court reporter, and it's ultimately later transcribed. But the ruling takes effect as soon as the judge speaks.
The administration clearly flouted that.
Yes, I think they flouted it. I think that an issue that the judge wants to examine, and was it in bad faith or was there any plausible misunderstanding about who did what when and when the flights took off. But I don't think that there can be any dispute here that the judge's order was flouted.
And they don't want to have discovery because probably discovery will reveal that they acted in bad faith. Probably. Yeah,
the discovery could reveal that because the information that we have with regard to takeoff times, Jeffrey, is totally in the hands of the executive branch. You and I know I have a presumption that every time the executive branch speaks, it's probably lying to you with an ulterior motive. But maybe they got it right. But discovery may reveal that that wasn't the takeoff times, that they took off at different periods after the court had clearly made its view known to the attorneys.
Well, my sense of human nature is that when you make a claim against somebody and they can easily prove that you're a liar, they're eager to do that.
Yes, that is correct.
Okay,
But
and
they
they're
don't,
not,
they don't
and
sit
they're not, and
silent.
they're not eager to prove the other people as being liars.
No,
So
they are not.
so they're making the claim for national security purposes. I assume El Salvador knew the status of these planes, right?
Well, on the landing, obviously, I'm not sure whether we would have alerted El Salvador when they took off. It's possible because but it was a long trip. It's not like got 20 minutes and you got to get landing rights in another place. It's possible that they alerted El Salvador in advance because apparently, if that was going to be the destination, they got to get permission in advance from the El Salvadoran government that they would permit to accept the deportees. So it's probably true. I do think that with regard to the timing, however, the president has claimed, that anything that he says that bears on national security, the courts have to accept as faith value. That's it. You can't
Well,
make any inquiry whatsoever, which is insane.
Well, this judge, James Boasberg, I don't know if I'm pronouncing his name right. Okay, from my understanding, he served 7 years on the FISA courts.
Yes, he's
And
well able to
and was the presiding judge for a year or two of the FISA courts. Any
Yes,
ever
so
allegation that he abused or misused
classified
information at the
information?
FISA courts?
None.
Okay, none. So what's the indication that a judge who served on the FISA courts has actually no knowledge of the concept of national security information and how to preserve national security information?
None. He obviously has great experience on that score.
Okay,
And the
he
record.
was in the FISA courts for the entire Trump administration.
Yes.
First administration. Did the Trump administration ever say, we're not going to the FISA court because this guy is there and he's a radical leftist lunatic, and so we're not going to present anything to the FISA courts because
No.
this radical left lunatic is on the courts?
No, and Judge Boasberg, one that really rebuked the administration relating to FISA warrants targeting Carter Page, which is a big cause celebre, among the Trump supporters. So there's nothing in his record that indicates that he's, biased in just an automatic echo chamber of a liberal. I think he calls him down the center. He's the chief judge of the U.S. District Court now. It doesn't mean I would agree on everything he says. Everybody has some prejudices, but there's nothing in the record that shows that he's got an anti-Trump bias whatsoever.
Any indication he's a lunatic?
No, he's got a solid reputation among the judges and among attorneys before he became appointed to the judge. He first was on the Superior Court here and then was elevated to the District Court. Nothing like, none of that sort. And this is the thing that we need to additionally understand, Jeffrey, is that not all judges are geniuses. But the reason why we give more deference and accept judicial process when it comes to interpreting law than we would that Congress interprets as law, or the executive branch interprets its own power, is because they serve for life, they're independent, they don't have an ounce of the ulterior motives that we know the executive or legislative branch have to do when they're interpreting their own handiwork. They don't run for re-election. That doesn't mean that they're perfect. That doesn't mean that they can't stumble. But compared with the even-handedness that you might confront in the executive branch and legislative branch, and I've been there a long part of my life, it's like living in paradise. And I've lost cases before courts, but at least I have a chance to argue. Unless you have a lot of money, you don't even get in the door to argue your case to the executive or legislative branches.
Yeah, I'm just trying to. All these claims they're making are just claims to incite and foment, his mob, to intimidate this judge and other judges and to delegitimize the courts or to delegitimize any dissent from his position.
Yes, and I think the next step that's worried, at least the possibility is worrisome, Jeffrey. You know that President Trump has ordered removal of Secret Service protection of many former members of administrations. And Chief Justice John Roberts has voiced alarm that there's an increasing number of threats against the lives of federal judges because the polarization of law and the politics. And I worry that President Trump may remove that Secret Service protection, even from judges who are confronting death threats or their family. And that, in my judgment, would be another long step towards dictatorship.
Yeah, there was a study done by a couple of academics, and they're careful to say that they only had the data during the Trump administration, and they haven't yet looked at the sample from the Biden administration. So they were clear to say that they're basically making this statement, not accusing that fact that only Trump would behave that way. They don't know whether Biden would behave the same way. But when they looked at the pattern and they studied all the applications for when Trump set the tariffs in his first administration, they checked on all the tariffs that were granted, all the waivers and exceptions that were granted, all the people who applied for waivers and exceptions, and the strong conclusion they made from studying the data was, and again, they're not making the accusation only Trump would do this. They're saying they can't comment on Biden because they don't have enough data yet to study the Biden administration, and they plan on doing it. But the conclusion was that Trump was rewarding his friends and with exemptions, and he was using the tariffs to punish political enemies. So this was not a neutral application of the tariff to protect national security, or to benefit the consumer or to benefit producers. He said, I can do all these tariffs. People knock on the door and say, give me an exception. And then the question is what are you going to do for him in order to grant an exception? And if you don't do a favor for him or something that makes him happy, you don't get the waiver, you don't get the exception. Worse, you might get punished for not doing what he did, and that was the conclusion for that. So what you're saying now, the evidence is there, is that is how he behaves. Obviously, he's behaving the same way towards these law firms that he's now, not only not allowing them to be hired by the government, they're not even allowed to enter federal buildings. So I don't know how much more. Maybe if he finds out somebody didn't vote for him, maybe they'll never be able to enter a federal building. So clearly these are punitive measures taken because people don't support him.
Yeah, he's already lost, at least in the initial rounds, his effort, I call him, to excommunicate Pekin's Koi law firm because it represented Democratic interest. But a federal judge already said, wait a minute, this is clear violation of your right to free speech and free association and to litigate. You have a First Amendment right to seek court redress for grievances that the judge had ever seen. So I think we're going to see the judges push back on this score. But why are we even entering this kind of equation? So punitive, and it's obvious that this has only to do because he disliked the fact that they were representing certain causes. Doesn't he think, look at all the lawyers who are representing you, Mr. Trump. You think when you're out of office, you think you want to set a precedent that means all of them are going to be out of a job forever, that they'll be boycotted and excommunicated by your successor president, and that's okay? And maybe you don't care, but your lawyers ought to care. That's what kind of stuns me, Jeffrey. Wouldn't the lawyers go to Mr. Trump and say, my God, what's my future, as soon as I leave? And the president in the White House isn't you. Then am I going to be targeted too? I can't enter the federal buildings anymore.
It doesn't seem to be any of them want to push back. They just want to do what they want to facilitate whatever he wants. It seems to be the case.
Yeah, for the time being. But the other thing I think you're mentioning, Jeffrey, is that there was a journalist many years ago, Michael Kinsley, and he said what's stunning and frightening in Washington is not what's illegal, it's what's legal. Because what you've described, Jeffrey, is a form of legalized bribery. You do X,
yes,
okay, help me. I'll give you a benefit on the tariff side. That's bribery by any ordinary understanding, or extortion, one or the other. But one of the reasons why least in my judgment, I think, Jeffrey, you probably share this, why we want to minimize the breadth of government is we know whatever your good intentions are, politicians always act for ulterior motives. It's
Right.
never for a neutral principle. It's always what's in it for me. You might want them to be angels. You might want them to be Jesus and Moses and Muhammad. They're not going to be that way. They never have been that way. And that's why small government reduces the mischief that they can cause. And the reason why government mischief is worse than private mischief is because government has a monopoly of violence, the guns, the military, and the money, because that's how they get taxes, and they have the control over the currency. It doesn't mean that you paralyze government, but just means you use your brain and say, even you have the best intent possible, the people who are going to wield this power are going to be sociopaths. You really want to give them that power. And that's the reason why I favor, at any opportunity, make government smaller. It doesn't make the world perfect, but it's better than all the alternatives.
Well, it's, I think, also the case equal is the less government does, the less reason there is for people to lobby and corrupt it.
Yeah.
The less government intervenes in our life. Once government takes steps to intervene in our life, it's obviously they're going to be winners and losers, and people will want to influence the process because people don't want to be the loser. So they got to invest money to avoid being the loser. And the more consequential the government is in our lives, the more is at stake, which means the more money people have to spend to not be victims. You know, if your choice is to be the predator or the prey, you're going to invest in being the predator. So since Washington is not protecting our rights and liberties, but it's choosing winners and losers, you know, there's a lot of money in being able to influence people who are choosing winners and losers, you know, and that invites a significant amount of corruption, you know, and the government is not supposed to be choosing winners and losers. That's not its purpose. Its purpose is to protect liberty equally for every person. So, I mean, the initial design really left almost all those issues to the state and local governments and the people, and the federal government never was really that consequential into people's day-to-day lives. You know, it wasn't until, you know, the broadening of the application of the of interstate commerce to mean something. You know, when Madison talked about the reason for, you know, the interstate commerce clause, it wasn't for giving the federal government to all the power it did. It was just to prevent states impeding the flow of merchandise across states. That's all the purpose was. You know, it was not meant to give the federal government control over all commerce, which is basically what's happened now, is it's been interpreted that, but Madison's own words are in conflict with that. You know,
he wanted a free trade zone. That's what it was, to encourage commerce. So he wanted to reduce the trade barriers through a free trade zone. And that's what happened for many, 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 many years, you know, probably for 100 years. But you're right, Jeffrey, with regard to the money issue. If you read, and I've read all the early Congresses, the presidential rates, there were no lobbyists, there were no campaign finance issues whatsoever. No one, they knew that they could make more money going out and doing an Eli Whitney, doing the cotton gin, making steamboats. That's where the money was. The money wasn't in Washington. So our genius was invention, doing things, the Pullman, Thomas Edison, whatever. So that we're filing patents, you know, hither and yon, Alexander Graham Bell. It wasn't in Washington. So no one was putting their money into Washington because it wasn't doing anything. There was no return on investment. It wasn't until the government, starting with the Interstate Commerce Commission and railroads in 1887, and then started to get involved more and more. It was on the installment plan rather than all in one, got involved in doing what you say, choosing winners and losers. That's when the money appeared. Until that time, there wasn't anything in regard to money. Read the campaign of Abraham Lincoln, the Lincoln-Douglas debate. Do you think there are people, you know, who are lobbyists there attending the debates and giving campaign contributions? I mean, that's absurd. But later on, when it became return on investment was very, very promising, then they turned the money to politics. That's where we are today.
Yeah, I argue that one of the reasons we've had this, many economists have said, why do we have this productivity paradox, and why we've had this significant decline in productivity that we've had as a nation. And this obviously has had a negative impact on the middle class because wage gains are tied to productivity gains. And I say, because the incentives have changed, because right now, after we had a lot of debt and inflation and things like that, what do we have incentives? The business make more money lobbying Washington and getting perks and privileges, so they don't have to invest in innovation. They can, if they get privileges, that preserve their profits without continuing to then have the need to innovate. And then we subsidize debt. So now they make money. I can sit back and say, I can think about all day of trying to how to figure out how to make my business better than everyone else's. Or what I can do is, the government is subsidizing me borrowing. I can issue a lot more debt, have a lot smaller cost of capital, and then go to Washington for more protection and more benefits. And I don't have to worry so much about how I can become the most innovative firm alive. All I need to do is get the protections and privileges from DC, and then Wall Street from the above. That'll pump up the stock price. And I don't really care. So the workers, I fire a few workers. They don't make a good, decent living. Who cares? So, I could find some bodies put there. But at the end of the day, as long as I got my friends in Washington giving me all these perks and benefits, restricting competition, creating barriers to entry, and because I'm successful at that, Wall Street will finance me at terms that nobody else can match. So I could deter entry, and I can make more money deterring entry and preventing competition than being the best competitor in a competitive marketplace.
Yeah, now let me explain that in granular level, Jeffrey, exactly what you've said. To your point. After Frank Dodd created a monstrosity of regulations regarding the financial industry in 2010, Jamie Dimon said of Goldman Sachs, hey, now we build a moat around ourselves. Nobody can get in because the only handful can pay lawyers $2,000 an hour to understand all these regulations. So this is the greatest thing we could imagine, Dodd-Frank, that purports to be for the consumer and is attacking the big banks, accomplished the exact opposite. And that's Jamie Dimon. He says, okay, now we don't really have to do anything. We can start running victory laps because we got legal protection against competition.
Yes. So that's where I invest my money, protecting myself against competitors and getting, because I'm successful at that, I can get privileged cost of capital. And if people can't match my cost of capital, they can't compete. I make it very expensive for them to be able to deter entry into my business and competing. And then the few competitors I have, we'll figure things out. There's enough ways for us to collude without appearing like we collude, to continue to all agree that we want to deter entry, and that way, that's the easiest path, to money. And this is all because the government is picking winners and losers, and people spend a lot of money, again, not wanting to be the prey. So you have a choice. If you're not the predator, you're the prey. So the deep pockets become the predators. Everyone else becomes the prey.
Yeah. Madison described that issue in a little different way, Jeffrey, but he was very prescient in the Federalist Papers. He said, we do not want to have a system where people profit by speculating on public measures. That's like, we do not want that in the system. And that's what we have, deluxe level, speculating on public measures. That's what it is, instead of just building a better mousetrap. It's the opposite of what the framers wanted to encourage.
Now, Bruce, what are the cases that I brought up to you, the cases that are of interest to me? I mean, I think there are a lot of other cases with respect to, these issues of how people were fired and the legitimacy of, them being rehired. Like there was this issue of, in one of the stories I read is that in one of the cases, the OPM, the Office of Personnel Management, fired people, but it fired people that had no right to fire people.
Yeah.
And then the person who headed up OPM refused to testify. So when the judge was asking, I want to know what happened there, the head of OPM had filed an affidavit to the courts and then withdrew it after he was called, to test them. A lot of this information is not getting out to the public. All the public is hearing, especially the MAGA people, who don't read any publication where they're getting told the facts. Okay, so I mean, these are the people I'd like to reach, and just for them to know what the facts are before passing judgment. The fact is that the OPM doesn't have the power to fire them, and clearly, if you're going in, these 18, 20-something-year-old people, they were not going in doing performance reviews of people. Okay, if not, you wouldn't have gotten a wholesale file of firings of people on probation. And again, probation doesn't mean you're a mediocre employee who now you're on a special watch list. It meant basically you're either new, and haven't been there for a period of time before your position, or recently promoted. But it doesn't mean you're a group of individuals that got a lot of poor performance reviews and they've been put on notice. And the worst thing that they did, again, if hopefully any maggot knows how cruel this is, okay? So clearly, if you're just going in and firing people on probation, that's not a consequence of any thoughtful review process, okay? Yeah. If you send a letter out to them that where you never performed a performance review, there's no evidence that they performed performance reviews, they fired people wholesale without evaluating what work they really did, and independent of whatever performance reviews they had previously, you fire them for cause because of bad performance reviews. I don't know how anyone could justify that. They know that what they did is a lie. They know they didn't do performance reviews, and they know they did not have the information necessary to write the letters they wrote to people telling them that they were fired. They know they didn't go through any of that process. So they know everything they did is a lie. So why should a judge not review that? And and I have argued, and I've argued this kind of tongue in cheek, is that I think Musk should indemnify the American people, that if his actions cause these types of cases, he should indemnify the taxpayers for the incremental cost, because think about how stupid this is. They fire people, they claim it's for cause, but they know the people they're claiming they're firing for cause, they never did a performance review to make that statement that they were fired for cause.
Not only that, Jeffrey, point out, they have no capability of doing a 19-year-old is going to do a performance review on the FAA employee, veterans, and they don't have any competence. They don't even know what a performance review looks like.
But
and
the
other thing that has happened is now we have a court saying that since de facto, Elon Musk has been acting as a principal officer of the United States, he has to be confirmed by the Senate, and everything he's doing is illegal. In fact, that argument was substantiated when Trump, about a week ago, said, well, speaking to his cabinet, he says, right up to now, Elon has been the director, but going future, he'll just be an advisor, which was a tacit acknowledgement that up until then, he was the super cabinet official who was never confirmed by the Senate. So he's just causing chaos everywhere, huge inefficiencies. And you're pointing out, he should indemnify. He's got plenty of money. He should indemnify the United States for all of the loss of efficiency, loss of payments that have to be made because people were illegally fired. And all right now, they say because he's doing so much, everybody just steps in and applauds it and says, well, he's just creating chaos. Well, chaos for the sake of chaos is not a good thing. Whoever does just chaos and expects anything good to result from that. There's a way to do this methodically, carefully, fairly, and it should be done. And one of the things that I most regret, Jeffrey, is Musk and Trump are giving downsizing government a bad name. I don't want it to be a bad name. I want it to be done in a sensible, careful, thoughtful manner. It can be done. But, after this, you'll be accused of a Musk-Trump nuclear bomb if you want to do anything sensible. So it's going to create almost impossible to have a thoughtful, educated debate over downsizing government.
Well, wasn't Clinton able to accomplish that with the commission Gore set up in basically getting to a balanced budget and downsizing government, that they did it through a methodical process?
Well, they did it. They did it legally. I don't know how much it stayed down. I think that because they never really went after the military-industrial complex, that was hands off that, and that's really the driver behind the huge amount of money. It's almost all of the discretionary spending is all the military industrial complex, and they didn't lay a glove
And
on
Musk
that.
has done
But
nothing
another
there
thing,
either.
but he
Musk has
does,
done
but
nothing
he did have the record of producing a budget surplus,
there. Yes.
which is certainly not anything we've seen under Bush or under Obama or under Trump or under Biden or anyone else. It's like we're out of control now.
Yeah. So right now, I want to finish up because I want people to know that once you're fired for cause, apparently, from what I read, you're not entitled to unemployment insurance.
That's well, the unemployment insurances are creatures, Jeffrey, of states. They have different rules, but in general, that's an accurate description of the state.
Okay. So many of these people who they know were firing just to downsize government, they fired them in a way that probably deprived them of unemployment insurance. Okay. And they don't care. Okay. And if they ever get interviewed again and are asked, were they ever fired for cause, they will now have to say that they were fired for cause when they might not have really been done anything to be fired for cause, only because they were just fired and they got a letter. So this was not only a function of trying to downsize government, they really dehumanized. You can fire people and still have them preserve some sense of dignity. You can go to them and say, we're eliminating this function. We're making supposedly that's what efficiency means. You're not firing people because they're incompetent. It means you're reducing headcount because you can do the same tasks more efficiently. Okay, so it doesn't mean that person is a loser. It means you've been able to figure out how to organize activity using less people. Okay, so it doesn't mean that person who you fired is a loser. It just means you know how to run the business better and more efficiently. That's what government efficiency is supposed to mean. Okay, or any efficiency is supposed to mean. So, so they could have just fired people by saying, we've done a review of the processes and procedures. We think there's a lot of red tape here we can get rid of, and thank you for your service. Your service was wonderful. We're happy to give you recommendations, but, we're shrinking the responsibilities of government and we're shrinking the activities of government. They could have handled it that way.
Yeah.
But clearly, they didn't do it that way because their intention was not to really make government more efficient. So their intention was just to create chaos. Okay. Yeah. And again, going back, what we're doing. So the judges are coming back saying, the way Doggy was set up is a fiction. Okay. And Musk, and you're right. Trump not only said Musk is in charge, Trump put the chainsaw in Musk's hand.
Yeah.
Because he told Musk, go harder, right?
Yeah.
After he told him not to go harder, then he said, get rid of the chainsaw and get a scalpel. But first he told him get a chainsaw. So Musk went around with his chainsaw. Okay. So showing people he's in charge, he's got a chainsaw, and he's going to use a chainsaw. So
the other thing that he did, Jeffrey, he calls USAID a criminal organization, terrorist organization. Anyway, he's so reckless with use of language. Anything that he doesn't like, he accuses of criminality and some kind of ulterior, sordid motive, which to say is not the way that we need and should ever operate as a government. You pointed out we need to treat people with dignity. It doesn't mean they have to have a sinecure, but it doesn't mean that we try to disgrace them. We try to gratuitously harm them, denigrate them, and that sort of thing. We need to understand we're all Americans, e pluribus unum. And we can be civil to each other, even if we disagree on policy. We have processes by which we resolve the disputes over policy. That's what an adult government looks like. And now we have little kids in the White House. Jeffrey, I have to go in 3 minutes to.
Okay, so Bruce, what are the things I didn't give you an opportunity to talk about that you'd like to speak about in the last couple of minutes you have to speak? And sorry.
Well, I think that it's important that all the viewers on this understand that you can be effective if you write in the judges, you write in the legislators, the White House. We want a government of laws, not of men. Ultimately, we are the sovereigns. The highest office of the land is citizen of the United States. Sovereignty is with us, but it's not going to work unless we exercise our voices. And it may seem that it's not useful, but I can tell you it is. Again, to repeat my personal experience at the time of Watergate and the firing of Archibald Cox, when 30,000 telegrams a day poured into the White House and Congress in protest, the members stood up, the White House stood up, Nixon had to leave. It was those 30,000 telegrams every single day pouring in. We can do the same thing. The effect will be the same. If they think they're going to lose power because the votes are running away, they will change their attitude. That's our last guardrail that we have right now.
Thank you so much, Bruce. Those are very wise words.
Yeah.
And always wonderful to speak with you.
Okay. Thank you, Jeffrey. Okay, thanks.
Okay, bye.
Bye-bye.